We will now turn to item C, which is a work session on zoning text amendment 1811, telecommunications towers, approval standards. I'll turn it to the chair of the committee in a moment. I just want to reiterate, this is a work session, so I think today we will go through background on the issue. We will, talk through the issue extensively and then talk through it some more. And this would be the day to surface ideas that you might favor as potential amendments. We don't need to have motions today. I think we can just surface ideas. If you have an idea, you should talk about it today. And then we have scheduled 2 weeks from now a vote, and people can put, council members may put their if there's amendments, on paper, and everyone can have that in advance, and that way, we'll have a thorough process. But today, I think we should ask questions. I know that this is a challenging issue, and the committee's worked on it extensively, and I'm going to talk a little bit about the process. But again, today's work session, there won't be any votes, no straw votes, no votes on amendments, no motions needed. But if there's something you're thinking about, you should talk about it and describe it, and then that way we can all kind of understand what each other is thinking about. So now I'll turn to the chair of the committee, Ms. Florine.
Thank you. Well, this has been an interesting conversation. As you will all recall, that we started out with a different bill several years ago. We had a really vigorous, shall I say, after we had the public hearing, and I forget if we'd already had a committee meeting, but we had another committee meeting, at least the Fed committee did, up in the Gaithersburg area, and we heard a lot of concerns. So we pulled that bill back, and as you will recall, the county executive proceeded to introduce the bill, send over the bill that we recently approved, having to do with the location of these small cell towers in more urban environments. This is the follow-up one about how they could function in more residential environments. And naturally, the folks who were concerned about the previous bill remain concerned about this one. You all know, and we all know, that one of the major things that bothers people is our concern about radiation and health effects. And everyone is well aware, of course, that as much as we may be concerned about that under federal law, that is not something we can address, much to the disappointment of lots of our residents. So what we tried to do is really try to shape a process here, really, to protect the community. We don't know what's really going to happen with cell phones. Okay, everybody, if you raise your hand if you have a cell phone. Community? Everybody? Come on. Come on, everybody in the back. Officers? Cell phones? Yes. Okay. Do you have them with you? You have them with you, and most of you are on them, possibly downloading kitten pictures as we speak. This is the challenge. What's next? We don't know. So is Verizon going to go to some whole nother system? We have no clue. What we do know is there going to be another approach? There's new technology every couple of months. Mark, is there a new Apple phone?
Yes.
Yeah, Mark would know. You don't? Yeah. You've been busy, huh?
I've been busy.
Usually we can count on Mr. Aldrich as our leader in technology here. Yeah. So this is the challenge. How do we plan for a future that's kind of unknowable? This is the real challenge for all of us. We want the people who want to download cute kitten movies on their cell phones to be able to do that, regardless of our views about that. We want them to be able to turn on their dishwashers from their cars as necessary. We want them to do whatever the new technology permits them to do, because people who live in Montgomery County are pretty up to date, very educated and thoughtful, and are in the game on the future. So that's our challenge as policymakers. What's the right direction to go in? So although we have terrific and really smart staff, we don't know what the technological future is for all of us. We don't know what the wireless providers are going to come up with next. Maybe we won't have wireless. Maybe we'll have something else. Who knows? But what we know is that there has been a system that's being advanced that we have a certain obligation to address. So our challenge here is trying to shape a process that protects our communities. I don't know what the news is today about the FCC being pressured to preempt local governments on being able to regulate this stuff. I know that there's pressure at the state level for that to occur. Last we met, Mr. Zients, the FCC was issuing various statements to the effect that preemption was somewhat likely. I know that in our last committee meeting, we understood they'd already taken the view, or taken the direction, as I recall, of cutting into or minimizing the ability of local governments to collect fees, on providers in the right-of-way. Isn't that right?
Yes, and they issued a 120-page order or ruling that did that, and a number of other things. I think I'm not sure if they published that in the Federal Register yet, but certainly it's something that the county and other jurisdictions would want to appeal.
That stuff is going on. I think we were going to sue them over this. Is that correct?
Seek judicial review.
Seek
for sure,
judicial
yes.
review.
So
our challenge is trying to stay ahead of the curve here. That's really it. And is there a perfect way? Well, we in the committee have tried to listen to everybody. There have been multiple meetings, hearings, and so forth. And this has really been the county executive's initiative. So, Ms. Nermi, you want to come on down, because this is really your bill, to find a way for us to have a hand in shaping the future of whatever devices may be possible and locatable in Montgomery County. We are losing our ability to control these things because of acts by others, and we're trying to put a marker in the ground that this is how Montgomery County can find a balance between industry demands and needs that are being addressed at levels above our pay grades, and at the same time respecting our communities and their concerns about visual blight and locational issues. So that's what you have in front of you. What we've ended up doing in committee, I'll let Jeff take you through the main things, but basically there are two categories of these poles. One is the replacement of or addition of these devices to existing telephone poles. That would and that's those of us who live within the trapezoid in the lower part of the county, and Mr. Ellich will know what I'm talking about here, are familiar with these the telephone poles and have a lot of them around us with a lot of stuff on them of every sort. If you look up in most of the down county, there's a lot of collection of things, and there's a certain amount of community concern about that stuff in the pole, but also many of that that has been there for some years, and we are somewhat accustomed to it as a community in our denser communities. The bigger issue is for those communities, newer communities where utilities are undergrounded. And so as a matter of course, those communities usually are not used to seeing these poles in the right-of-way, except to the extent that they have poked out of the ground in terms of light fixtures that might meet HO8 kinds of standards and the like, but more modest devices, not the big poles that we're used to farther down county. And so consequently, to those folks in particular, they have raised lots of concerns because this isn't what they expect to see. So we've tried to, so in that category of uses, what we have come up with is that these devices located on poles in those communities would still be considered a conditional use, and would go through a review process that would involve concerns about compatibility and setbacks. So this has been sort of a fine balance in trying to find, appreciate that one use was sort of classic in terms of existing poles, and where new poles were being introduced, we appreciated that they were disruptive to the landscape and warranted a more sensitive approach in terms of dealing with them. So that's sort of a generalized summary of where we've ended up. We've also extended the nature of the setback in those residential areas in particular. Again, trying to find a balance and respecting those neighbors' concerns about things being too close to their homes. And again, an unexpected entrance into their view shed and all the associated concerns that have to do with the location of these devices within existing communities. So that's what this set of recommendations does. And with that, I guess I'll turn it over to either Ms. Nurmi or Mr. Zients. Ms. Nurmi, do you want to say anything about this before Mr. Zients gets into the details?
No, I think he's able to. I think he's able to explain it just perfectly, and you did a very good job. Thanks.
Okay. So I'll now turn over to Mr. Zients. Thank you, Jeff.
And that was a very good
Get it
summary.
covered, sir?
There is one thing is that the proposal sort of divides the world into two categories: those that are wooden poles, or the Cobra light poles, the tall things that you see more in commercial areas or along wide streets that are 22 feet or higher. Both of those categories of poles would be approved by conditional use with setbacks. Within the conditional use category, what was originally proposed was a 30-foot setback, and what the committee has recommended is retain the 60-foot setback that is there today, but allow it to be reduced if it's necessary to avoid a denial of service. That is, if you couldn't get a different pole with a greater setback somewhere within the radius of service of that antenna, then you could have a shorter setback at that. The committee also wanted greater assurance on taking down pre-existing poles that are being replaced by another really utility pole. In that case, that's where this problem occurs, and drafted some text to do that. The committee wanted to make sure that there was better communication with between the Tower Committee's recommendations and DPS, and required that the recommendation be forwarded to DPS so they had it in hand and then could enforce. And it also has a provision that requires those companies that had attachments to these poles to remove them within 60 days of having the new pole. That is typically the problem with taking down an old replacement utility pole, is that there are other people's equipment other than the PEPCO on those poles. RCN, Verizon, Comcast could all have lines on those poles that they have to be taken down and replaced on a new pole sequentially, because nobody really wants to touch the other guy's equipment for liability reasons. But the committee did what it could in trying to add protections along those lines. Other than that, it is essentially the committee's recommendation is the ZTA substantially as it was introduced. I can go through the memo at the council's discretion.
Okay. I don't know that we have to go through all the details of the memo one by one, but I think there will probably be opportunity and need to refer to what's in the memo that you've produced. Again, I think what we have here is a very simple ZTA, and well, it is actually. It's rather elegant and simple. In communities that have underground utilities, it's going to be a conditional use. There will be hearings. There will be input. There will be negotiation. And in communities that have utility poles, like the one where I live, where many of us live, it will be a limited use with a 30-foot setback.
60 foot, unless a shorter setback is necessary. Oh, no, limited use.
Limited use.
Sorry.
Wow, I know this better than you do.
I'm sorry. Now, I'll be quiet.
So it's very simple. I know there's a lot of concern about this issue, and the response of this ZTA is that where we've heard the most concern from communities about replacing their fixtures, their light fixtures in their neighborhood, these small, fairly refined, aesthetically pleasing structures, we've heard a lot of concern about bringing in new infrastructure into these neighborhoods, and where that is contemplated, it would be a conditional use, and that would help us to negotiate and, through the Tower Committee process, find the best way to deploy that infrastructure in the manner that is most, compatible with the neighborhood. I wanted to just describe a little bit about the process that we've gone through. The chair alluded to this. This bill was, a ZTA on this was introduced 2 years ago. 2 years ago. We've had 3 public hearings on this issue. That's pretty unusual. We've had 5 community meetings. The executive branch convened a series of community meetings. We've had 5 drafts of the ZTA released for public comment. So we have received public comment through 5 drafts publicly. We've had 2 down county and up county advisory board briefings, and we've had, I think my colleagues can attest, countless interactions, small meetings, individual meetings, phone calls, emails, Facebook comments, tweets. And as a result of the public input, we've added a prohibition against using certain classes of poles. We've added conditional use requirements to minimize the visual impact of replacement poles. We've reduced the antenna size. We've added shroud requirements. We've reduced height increases for replacement poles. We've added and increased setback requirements for replacement poles. We've added a requirement to remove old poles and removal of wires attached to old poles to address double pole issues. So we have made a large number of changes through the committee process, through the executive's drafting process, to the basic ordinance, which isn't to say that we're done. There may still be additional changes, but this has been out for public consumption and change, and it has been changed substantially as a result. The FCC recently issued a draft order that preempts the county, would preempt the county on many of these concerns. And I believe we should challenge that in court. But I understand that there is a real benefit to having our own ordinance in place to support a court challenge. So I'd like to ask a question about that in a moment, but I think it's a parallel issue with the state of Maryland. The state of Maryland, we know, is considering legislation that would preempt local authority, and having our own ordinance in place is a very valuable tool as we go combat this effort in the state of Maryland to preempt us. Whether that ends up being grandfathering us or whether that ends up being pushing a statewide bill to reflect what we've done, who knows what the benefit would be, but having enacted our own ordinance would be a very strong advantage for us in the state. But I would like to briefly ask Mitzi or Joy if you could explain this question about how we would challenge the FCC in court and what role would it play having an ordinance of our own to rely upon, to point to in our legal case.
Thank you. Mitsuko Herrera, Department of Technology Services. So the FCC orders will take effect somewhere about 90 days plus 1 to 3 weeks. Having the ordinance in place now would give it an effective date prior to the effective date of the FCC order. The specifics in the bill are designed to withstand the FCC challenge. The zoning requirements, the FCC's order is written so that things that are much larger than what we are doing would be covered, and they're subject to specific shot clocks to take action on those items. So the things that we've done in part in the ZTA are designed to enable us to comply, and so that the local standards that we've adopted can be preserved. The primary places where the FCC challenge is going to be difficult is going to look around the cost and fees, which are not addressed in the ZTA, but the ZTA is a necessary step to move forward with starting to determine those costs and fees. The other things are that the FCC's orders are in essence an attempt to take public property, give it away at no cost, without any corresponding obligations to provide service. And the FCC's orders are designed to be a slippery slope so that they are first bringing in wireless, and then they would come to say that wireline has to be equivalent, and then potentially they would run to say that cable should be subject to something similar, and they've already started on that path.
So having our own ordinance in place enables us to make the argument in court that the FCC's action is arbitrary and capricious.
Correct.
So if we don't have our own ordinance in place, then the FCC and the people who want the FCC to preempt us can say, look, they haven't done the job.
Correct.
They can't do it.
We've already been in several filings, they've put footnotes and they've called out Montgomery County. It certainly would be a case in which they would come and they would make a claim that Montgomery County has worked on this for 2 years.
And we are a leader in this national policy-making arena. We file comments. We work with other local governments and we file comments. We are advocating before the FCC. If we can't actually do the job ourselves of creating an ordinance, and we're the ones leading the charge to protect local government, what is that going to say about local government's ability to get the job done? It's not a very good statement. So this is the real stakes here. We have the mantle of leadership for local government, and we have to do our jobs and enact an ordinance. And if we don't, then we are creating evidence that local governments can't do it. And then that's going to put local government in general in a very weak place to push back against the FCC order in court, to push back against preemption in Congress or in the state legislature. Now, I want to just observe, I've become more familiar with this, serving over the last year and a half on an advisory committee to the FCC. It's called the Intergovernmental Affairs Advisory Committee. And I was put forward for membership through NACO, the National Association of Counties. And I'm one of many local and state government officials on that committee. And in the work of that committee, I led my colleagues there, working with Ken Fellman from Colorado, to submit a comment to the FCC strongly opposing preemption of local government and urging the FCC to respect local authority in siting infrastructure. The county executive and I met with the Chairman Pai, we met with Commissioner Carr, we met with Commissioner O'Reilly, we met with Commissioner Rosenwhistle, with Commissioner Clyburn. We've met with every commissioner at the FCC, urging them to respect local authority and to help us achieve a successful deployment rather than to try to roll over us. So I was very disappointed to see yesterday advocates in the community put forward this idea that I should recuse myself from the work that I'm doing on small cell deployment because somehow I have an affiliation with the FCC. I can tell you that the industry and the chairman of the FCC does not like the views that I have been espousing, and in fact they've recently packed the committee that I've been on in order to dilute my voice and the voice of other people who share my view that local government should be respected. And they are trying to pack that committee with people who are prepared to support preemption of local government. That's how much they don't agree with me, actually. So proving that no deed goes unpunished, I guess. My service in advocating on behalf of local government before the FCC has now been twisted around, in a similar manner to other information that we've seen twisted around, nonsense that we've heard from some about this issue. So, I would just urge my colleagues to keep their eyes on the ball here. We are a leader in 5G issues nationally. We are doing the hard work of trying to figure out how to strike the right balance. There's no easy answer. This is not a simple issue, and we have a lot to gain and we have a lot to lose. We do have a lot to gain with our phones. This is the future of wireless. This is what this issue is about. You can vote against the future of wireless if you want to, but that is what is at stake. On the other hand, it's the future of our control over our right-of-way and our ability to charge the industry a fair price for the permitting work that we would have to do for their equipment. Do you want to give away our right-of-way? Do you want to let the industry walk all over us? That is also what is at stake. So these are big issues. I'll now turn to my colleagues for their thoughts. Mr. Katz.
Thank you very much, Mr. President. To join in what you're saying, from what I understand, from what we've seen today, that we've had about 27 different meetings, from various community meetings to meetings with the industry individually, meetings with residents individually, and I candidly applaud our staff and our Fed committee and everyone else in this. These discussions have truly gotten us from one spot to another spot, and I applaud that. But as was pointed out, the biggest concerns, and it's not the only concern, but the biggest concerns that we have are for the underground, those areas, those residents where the underground utilities are located. Where the wooden poles, that has, not that it's an easy discussion, but it's certainly an easier discussion to discuss how we can solve those issues. But where the underground utilities are located, that is a big problem. And it's interesting that the industry, though they are a utility, the cell phone industry is a utility. It is an unregulated, underline the word, unregulated utility. Does not go before the Public Service Commission, does not have their fees discussed. It doesn't have anything that a regular utility would have. And this industry wants to use the public right-of-way. They want to use the public right-of-way for free, which is in itself is to me is not the right thing for it to be able to do. I believe the FCC, and I think we should probably talk about that for a second. The FCC is called the Federal Communication Commission, and they don't want us to communicate. They want us to be able to sit back and have their residents just say, you got to do this because we say you got to do this. And that's wrong. That is absolutely wrong for what they're trying to do. I don't believe that they have the authority to force, I do believe they have some authority, but I don't believe they have the authority to force air right-of-way to be used, the public right-of-way to use. They certainly don't have the authority to force someone's private property to be used, so therefore why should they have the right as an unregulated utility to be able to allow the public right-of-way to be used? I think there should be more discussion on this. I know that when the National League of Counties, and I read their newsletter, I think this Monday, we had another one where there's counties across America that are extremely concerned about this. And yes, we are a leader on this, but we should not do this strictly because there's a time frame set up by the FCC. We should do this in a very quick manner. I believe that all the discussions we've had, and I have some suggestions for amendments and other things as well, but for all the discussions we've had, in many cases, it's individuals. We've spoken to the industry. We've spoken to the residents. We've had public discussions, but it's not with each other. And what I always like, and I've seen it in planning and zoning on many, many times before, is what I always call the charrette process. And it's not just my name. I mean, it's certainly something that's been used several times in planning. I know that in some cases there were those who called it a charade process before it started. But in my case, and what I've seen, is the charrette process actually has people from all sides sit down, actually listen to each other, actually have the same information that they have gotten in the that others have gotten. Maybe they weren't there at the table, maybe they were at the table and didn't listen as closely. We need to do, in my opinion, we need to do that quickly. We need to say that in their case, because we have to have everything finished by October 31st because of the zoning, we can't do that fast. I believe that should be for something that this next council does right after we come back early January. The council president should call and say that we need to get this solved. We need to have a working group that works on it while we're attempting to get it solved sometime in February to get this done, and then we can finally get this to rest. I believe if we can have everyone listening, everyone sitting at the same table and having a good discussion, I think this would be beneficial to everyone. I think it would be beneficial to the residents. I think it would be beneficial to the industry. Let's face fact, the industry wants the residents to be their customers. They don't want people angry. So therefore, we would be all, the residents, the industry, and everyone else involved would all be so much better served if we took one more deep breath. I understand we've worked on this for a long time. Mr. President, you've said that on the FCC that you were on that committee for a year and a half. We need to figure this thing out and not do it at this moment. I think we should wait to do it, and hopefully others will agree with me. Thank you very much.
Thank you, Mr. Katz. Mr. Leventhal.
Well, I want to congratulate you, Mr. President. You've had a really good year. You've gotten through a number of big controversial initiatives, and you've got some scars for it, but you really buckled down and identified some priorities, like the ZTA we passed last week for the breweries and wineries and cideries, which was, in my judgment, absolutely the right thing to do, but there's still some people grumpy about it. I don't know whether you'll succeed in getting through this ZTA this month. I will not vote for any delay motion. As with the ZTA on wineries and cideries and breweries, they're different, but what is similar is I listened very carefully to the objections, and I came to the conclusion that the fundamental objection couldn't be satisfied, and that anything we did to liberalize any economic activity in the agricultural reserve would be opposed by some. And that's just the way it was, and that there isn't a decision that this council will ever make that will be pleasing to 100% of people. Not any decision that this council ever makes will be pleasing to 100% of people. And so for that reason, because of my affection and concern for my colleagues who will serve on the next county council, I will not vote to postpone this agonizingly difficult vote to those distinguished elected officials, 4 of whom will be brand new and have not encountered this issue at all, other than to respond to questionnaires in the heat of a primary election campaign, which, let me tell you, is the worst way to make policy decisions. Do you agree with my position 100%? Yes or no? By the way, do you want to win the election? That's not a good way to make decisions. So, I've been called by folks who are not yet on the council, and some who didn't make it through the primary, saying, please don't do anything on cell towers, because they believe they're representing, the community. And there is no doubt that there are a significant number of constituents who are anxious and worried about more of these devices in their neighborhoods, and that their feelings are legitimate, and we have to respect those. And we made some efforts in committee to be responsive to those, and if there are credible and bona fide amendments now or later in the full council to address those, I'm wide open to those. So I'm happy to consider seriously and vote for amendments that seem, reasonable. I think that we are only buying ourselves trouble if we act in a manner that clearly violates federal law, or that clearly invites preemption, or that clearly invites court action by the wireless industry. So those will be issues. I don't really care whether it's 30 feet or 45 feet or 60 feet. I don't particularly care whether a particular thing is a limited use or a conditional use. I don't think it's responsible, and I've only got a few more weeks here. I really seriously want to be responsible. I want to cast votes that I feel good about, that represent good policy. And I don't think it's responsible to do something that we know invites a lawsuit that we will lose. I don't think that's responsible. And so some constituents have written me saying, look, there's this town in California that said, we'll never allow 5G here. We just won't allow it. And we're going to invest in municipal broadband instead. Well, that little town, if it has the wherewithal to provide FiOS to everybody in that little town, and that's a public expenditure it wants to undertake, that's great. 5G's coming to that town. One way or the other, the industry's going to get 5G in that town. And so this council could act in a manner that would have the effect of blocking 5G. But having studied this and having the benefit of really listened and learned about it, which the 4 new council members won't have had that benefit, and knowing, you know, how vigorous industry's interest in this is. I mean, they've met with me far more times than I wanted to meet with them. I mean, they're nice people, but this just is not my favorite topic. You know, and I would say the same thing to Joy Nurmi. God bless her. Boy, is she into this topic. She wants to talk about it and talk about it again and check in again. And, you know, I'm happy to find some reasonable middle ground now, but it's before us now. And if there are amendments that seem reasonable, you know, I'm open to those. In that regard, I would like to understand, Mr. Berliner has suggested that people ought to be notified in every event. And my question is, and I'm open to that suggestion, what could be bad about notification, except that what I don't fully understand, I've learned a lot about this, but there's still things I don't understand. I don't really understand the operations of the Tower Committee, and does the public have the opportunity to weigh in with the Tower Committee at any point? Because my concern, and I'm happy to work with Mr. Berliner on, you know, the 2 amendments he suggested or other amendments, if council members want to, you know, put their thumbprint on this and improve it still further. I offered some amendments in the Fed Committee, and in the full council there may be additional amendments. But what doesn't seem to me to make sense, and I'm asking Mitzi Herrera this question, is to notify someone without empowering them to do anything. And again, it's out of my affection and concern for the people who will sit in these seats in the future, that simply notifying residents but not giving residents the opportunity to do anything, any recourse, any place to take their grievance, is just going to, the issue will land right back here at the county council. The residents will say, what are you doing? You're notifying us of something. We can't do anything about it. Change the law. We want to stop it. If you're telling us it's happening, we don't want it. What do we do? So this notification proposal, which on its face sounds like a good idea, what could a resident do in the case of a limited use? Could the resident write a letter to the Tower Committee? Is there some way for the resident to express his or her potential? Not every resident will care. A lot of residents won't care, but some will, and they will have chagrin. What can they do with that chagrin if we notify them? Ms. Herrera.
Thank you. So the point is we have spent quite a bit of time. First, let me answer the question about the Tower Committee. The Tower Committee is an open meeting. It is not a public meeting. It's not a public hearing. Those are operated by OZA as part of conditional use. Those require notice, a further timeline, and frankly, there isn't enough time within the compressed timelines that the FCC has to take action that you could add that. But the point of it is what we are trying to do is to find a process. The Tower Committee right now already engages in where they ask the applicant, have you considered co-location, looking at other polls? So I think that there's an opportunity that we can create. It's a fast track in which there is an explanation that's going to be provided by the applicant. Why did I pick this one? Why didn't I pick these other ones in a relatively confined area? So the idea is we've already made changes in the Tower Committee so that those applications are made public and available on a website. There's a database and there's a mapping. So there may be a notice that's provided. You have a short window to file. You can review what's been submitted, and you can file comments on that.
Okay.
And the Tower Committee can review that, and as part of the recommendation, they will incorporate that.
Okay, so what I would suggest, Mr. Berliner, with respect to your notification amendment, is that the notification include it's not easy to explain this topic. So as best as we can, in the plainest possible English, explain exactly what Ms. Herrera just said. The Tower Committee will take up this application on this date. If you want to submit written commentary, you can submit it at this website. You've got to give people something to do with the information rather than just giving them the information. So that's my first point.
And I would just add to that, is that we would make that available through the implementing regulations, so that it's very clear on the tower website exactly what the process is.
Sure.
And it would also spell out where there's sections of federal law that don't allow the county to deny something, that those are set forward, and those would be implementing regulations that we put in place after the ZTA, if the ZTA is adopted.
Okay. Well, I want to commend Mr. Berliner. It was very helpful that he circulated his amendments in advance of this session. That helps council members if they can look at something and get their minds around it, and I'm happy to work with you on that one. I asked some questions in committee, and some of them were responded to and some were not. So if my colleagues will indulge me, I just wanted to go over that. I see that in a very short period of time, Mr. Zients provided a very short answer to my question, which is on page 12 of the memo. Because what this brings to mind for me with respect to the use of the public right-of-way is, how did the current infrastructure ever get put up? How is it that, given the opposition that you would reasonably expect to telephone poles and natural gas lines and sewage being pumped, you know, in front of your yard, how did those things ever occur? Because I do grasp the difference, what Mr. Katz says, that the water utility, the sewer utility, the electric utility are regulated utilities. Rates have to be approved by a public body, and service within the service envelope must be universal, and none of those things are true of wireless communications. I do grasp that difference. Having said that, I also grasp, and this is important, that wireless communication ultimately is going to be an essential mode of communicating, and we're already pretty much there, and it's only going to be more. And I do, you know, there are issues that I get very emotionally invested in, the right of everybody to download super fast data. I'm not emotionally invested in. Mr. Reamer, I think, is. He's talked about, you don't want to stand in the way of the future and all this ringing rhetoric. The future will come, whether we vote against it or not. We can vote against the future, and the future will still be here. And that little town in California and some other examples are just that. Some bodies of local officials are saying, heck no, #resist. I don't want the future to occur. I'm exaggerating, but, you know, well, the future's still going to come to those towns. There's just going to be additional steps and litigation and preemption and all of that. And in those towns, there will be 5G also. But I would like to understand, to the extent that it's feasible, how is it that the public's objections to ugly telephone wires didn't prevent the installation of ugly telephone wires? How is it that people's legitimate fear about natural gas, which is explosive, you know, a bunch of homes in Massachusetts, I'm pointing to Ms. Florine, who grew up in Massachusetts, blew up recently, you know, how is it that natural gas was ever installed? Now, I mean, we benefit from natural gas, we benefit from landlines, and we benefit from cell phones, but trying to put this in this new technological development, which involves the use of the public right-of-way, how is it that these other technological developments and access to important and necessary services ever occurred? That was a question I asked that I would like to understand better. And how do you view this latest technological development in an historical context?
Right-of-ways were first dedicated for public use, as a very general statement. It was first conceived, of course, for roads, and that's all that went in those. The very first case on a subdivision in which a right-of-way was dedicated in Montgomery County, somebody wanted to put a sewer line in it. God forbid. And the issue was whether that was a nuisance to the abutting property owners, or within the purpose of that right-of-way to service those abutting properties. And the courts determined that it was in the service of those abutting properties. What has happened over time, particularly with utilities, is the state has a regime, if you will, in which it mandates that what it declares to be a public utilities is allowed in the right-of-way particularly, and that involves the public utility poles. So in that respect, our right-of-way, which is really, we're a creature of the state, our right-of-way is commanded by the state already. So public poles can be there. The county on its own has determined that underground utilities should be franchised and allowed to use in the right-of-way. We do that on our own. Again, the reason for that is we think it is servicing those houses along that right-of-way. So we, by franchise agreement, allow those underground utilities. We have about a dozen separate franchise agreements. 2 of those agreements allow pole attachments for above-ground wireless types of facilities. And really, this is an expansion of that franchise agreements to particularly allow for wireless in our rights-of-way. I hope that's short enough.
Okay, I have a couple more questions and then I'll yield. Am I correct in assuming that, well, so one of the big challenges that we face is that everything one side of the argument says is disputed by the other side of the argument. So we have very well-meaning community leaders who are saying, we've got an alternative and we can live with this, and the alternative calls for greater setbacks or, you know, greater conditional use, and industry says we can't function that way, it won't provide us with the coverage that we need. And then the community leaders say, well, industry is just lying to you, they don't really need this. And, you know, on both sides, each side disputes the facts. Am I correct in believing that although there's an issue of whether the public sector is compensated for use of the public right-of-way, these wireless cell towers are installed at the utility's expense? It costs money to the utility to install every single one of these, and that therefore they are not going to install more of them than the market demands. They're not going to go willy-nilly installing expensive devices that consumers won't ultimately pay for, and therefore we don't know today exactly how many of these cell towers will be installed 3 years from now, 5 years from now, 7 years from now. But what we do know is that not one of them will be installed more than what consumers demand. Is that a fair assumption? If they don't need it, they won't install it. One of the assertions of the community leaders is industry doesn't need as many as they're saying they need. Well, if they don't need them, they won't install them because they cost money.
The successful companies will install them based on need. The unsuccessful companies will go bankrupt. I mean, there is a potential that they're wrong, but there's a greater likelihood than not that they will get a return for that pole.
Okay, and then I may have more questions later as the conversation goes on, but I also would like to know about the issue that I raised in committee, the broad issue of enforcement. This has been a big topic with the residents, and there's a big lack of trust. There's lack of trust in the county, and there's lack of trust in the wireless companies, and there's lack of trust in the regulated utilities. And Joy Nurmi, who, you know, I'm very fond of Joy. I really would like to talk to her about something other than small cell towers. We're good friends, and there's many other things we could discuss, but every time she calls me, she wants to talk about small cell towers, so I have to get her off the phone. She told me that my suggestion in committee that as part of the contractual relationship between the county and the wireless company would be required to agree to take the responsibility for removing all the other old and extraneous poles. And I do think this is a real and legitimate issue, that we can't do that for some reason. So what happened to that suggestion of mine? Because the committee agreed to that in concept, and we asked to flesh it out further. And I absolutely do think that if you're going to have this new high-tech device next to an ugly old wooden pole, and all of the carrying capability that used to be attached to the ugly old wooden pole can now be on the new, 21st century device, somebody's got to be responsible for getting rid of the ugly old wooden pole. And I understand that my constituents have no confidence that that ugly old wooden pole will ever be taken down. How can we address that?
So you really do want me to talk about small cells now?
Well, it's before us now, yeah.
All right.
Not on the weekend when I'm trying to, watch the Redskins.
All right. I'm actually going to turn it over to Diane Jones, but I will tell you that Cliff help me out here. Thank you. Cliff Royalty, our county attorney, said that you cannot compel a company to enter into a contract. And so Jeff and Diane Jones worked very closely together to come up with a different solution, and I'll let Diane explain it.
Thank you. Diane Schwartz-Jones with DPS. Mr. Leventhal, in response to your question, what the language we agreed upon would actually require that the equipment that is on a pole onto the replacement pole must be moved within a certain period of time. And based on what we've seen historically, one of the reasons that there's double polling is because the equipment sort of lags behind, and we work with PEPCO, and actually my staff meets regularly with PEPCO, and they have reduced the list of double polling, but they can't always get the owners of equipment to move the equipment on the schedule that they want them to. So now what this language that is before you in your packet would have would be a requirement that the equipment must be moved within a certain period, 60 days following the erection of the replacement pole. What this does is it gives the Department of Permitting Services the ability to issue citations, notices of violations, not just to the permittee, which would be PEPCO for the installation of the poles, but to the people who have equipment, the companies that have equipment on the old poles and who have failed to relocate the equipment to the new poles. And then PEPCO would really have no reason not to removing those poles. So this will be a very helpful tool in our toolbox, if you will. It is, we're not reluctant if we have a recalcitrant party, even with WSSC, for example, who just won't do what we need them to do as it affects the right-of-way. I can think of one in Bethesda where we issued citations, literally, after not getting compliance with letters and notices of violation. We issued citations on a daily basis to this particular contractor to the tune of a fair bit of money, and finally we're able to get that contractor into compliance. So this would give us a tool that we didn't have previously that we think would be helpful to accomplish what it is that we're all trying to accomplish.
And you'll find that text at the bottom of Circle 9, lines 139 through 144. It is in the committee endorsed text, because we thought you endorsed the concept and we wrote it out.
Mm-hmm. Okay, so the last thing I would say is I would appeal to my colleagues to do as Mr. Berliner has done, that I'm really open to other amendments and other modifications, but it would be helpful if we had a couple days to think about them and understand their implications and whether they are delaying the inevitable. Some of the amendments that we haven't seen yet, but that I've heard might be proposed, either fairly clearly deal with environmental effects, which we explicitly may not do, or would probably not provide enough coverage to provide adequate wireless service, which in the long run or the short run we will clearly be preempted from doing. And in fact, federal law says that you may not absolutely block these things. We've got zoning authority, but we can't prohibit them all together, as that little town in California that was brought to my attention did do. And I won't vote for anything that I think that's evidently preempted by federal law and that is just opening up the county to lengthy litigation and expense. We've got to remember litigation's expensive. I thank my colleagues, and I yield the microphone.
Thank you, Mr. Leventhal. Mr. Rice. Oh, wait, sorry. Quite slightly out of order. Mr. Berliner wanted to respond in there.
Thank you, Council President. Thank you, Mr. Leventhal, for raising that issue. And I also would cite you to the Tower Committee legislation, which requires the owning agency must receive and evaluate public input as part of the agency's decision process. So I presume from that language that if a letter, in fact, is sent protesting on whatever basis, that this is the means by which that protest would be taken into account and responded to or otherwise. So it is important. But this whole exercise has also led me to look at the Tower Committee legislation and ask myself, I don't know about you guys, but I didn't know the Tower Committee before all of this, and I don't know how it operates and whether or not it is appropriate under circumstances today for it to operate the same way it has. So I've asked Mr. Zions to look at this and advise us, as to whether or not there are any additional modifications to the legislation creating the Tower Committee in order to make sure that our public has all the due process rights that we think are appropriate, that residents, for example, perhaps should sit, perhaps as observers to the Tower Committee if they don't have other input that they can make, but somehow make this this process that is neither fish nor fowl, because it's not a adjudicatory body, it's an advisory board, but it's an advisory board that, as I understand it, we take their advice seriously.
They are invited to observe it, even when they've had conference calls, they have been provided that information. The agenda is published a week in advance, so, yes.
Do understand that, but I don't believe that the legislation that created it, for example, created resident advisors or some formal role for them to be observers from neighborhoods that have felt like, we don't know anything about this. So my goal, in part, to the extent to which we decide to move forward with this legislation, is to try and address what the community is feeling like, oh my goodness, we're not being respected here, okay? And I understand your work and Ms. Nurmi's work and all the meetings that have taken place. And let me tell you, there's a reason why all hell breaks loose at all those meetings, right? This is something that has our community's underwear up in a bunch, okay? That is what is true. It's a technical term, okay? And people are really nervous about it. So from my perspective, it is important that we bend over backwards in order to see what more we can do to accommodate their legitimate concerns. So Mr. Leventhal made reference to a part of my amendment, which was with respect to notice. The other part of my amendment is addressing the limited use, which really is sort of unlimited use, but is to say the same standards actually would be applicable under the conditional uses, which is the default should be 60 feet. And if 60 feet can't be met, then the burden of proof has to be on the carrier to demonstrate why 60 feet can't be addressed, can't be met, and that 50 foot can't be met, that 40 foot can't be met. If they're coming in at 30 feet, for them to have the affirmative obligation and the burden of proof to demonstrate that to the satisfaction of the Tower Committee. So that's the two pieces, colleagues, of the amendment that I shared with you by email, and I have copies here if you didn't get it, that at the appropriate time we will discuss. Ms. Nurmi?
The executive supports the amendment that you wrote up.
So part of, again, what I think is taking place in our larger community is they don't trust the FCC, they don't trust the cell companies, they don't trust government, they are not trusting. And part of the dynamic is what happens if we don't act? So Mr. Katz has said, can't we take more time? And part of what people like me need to understand, what our public needs to understand, is what are the consequences if we don't act now and wait till February, let's say, or whatever the date is that Mr. Katz suggested, for all those new council members. I promise you, I'd like nothing better than to leave as a gift for the District 1 council member this issue. It would be so nice to leave this to somebody else to handle. But what are the consequences if, in the judgment of Mr. Zions, you're our attorney, and if other attorneys care to speak, I'm sorry that our county attorneys are not here. I actually thought they should be here for this purpose.
Again, with risks and litigation, we tend to like to do this in closed session. But I can lay out the potential landmines that are out there. The first and foremost is we have about 120 pending applications right now.
And our current setback is what?
Excuse me?
Our current setback law is what?
Is 300 feet.
300 feet. So under 300 feet, presumably.
For new towers, right?
For a new tower. For a new tower.
And all of these would be new towers under our definition of new towers. And the issue would be whether that is presumptively a denial of service. Are there sufficient areas with 300-foot setbacks to provide coverage under the spectrums in use and the services delivered? That issue exists today under the current federal law. The federal law itself says that a jurisdiction may not prohibit or effectively prohibit service. Now, we've been very successful in the Fourth Circuit to have that provision read where there are gaps in service, that you had to be filling in a gap in service or have a demonstrated gap that needed filling that you deny and that would be a denial of service. Under the new FCC ruling, if that prevails, that denial of service is enhanced or augmented service in an area. So certainly under the new rules, which we will challenge, we are more likely than not for our existing code to be in violation of the prohibition of service rules. Now, we will fight that. We have the arguments in the existing Fourth Circuit opinions that we could use, but there is some strong likelihood that we would not prevail.
And so, without prejudicing our county's rights, should we, if Mr. Katz prevails, when we don't want to prejudice our county's legal position, but the argument would be made that if we do not move forward now, if we wait till February, that's effectively a moratorium on service going forward, and therefore that the applications that would have been filed and challenged would be able to be adopted as filed?
We do not have a legal moratorium on processing these. We would have to process them. We would have to process them under current law. Under current law, there is no doubt that we would deny them because they do not meet the setback
Thank you.
standards.
Moratorium was the wrong word.
And therefore, it becomes an effective denial by the denial of all the applications. I mean, I'm projecting a lot of things in this. I could certainly be wrong, but I certainly see that as a risk to non-going forward.
The Council President has given voice to this previously, that if we, in the view of some, particularly in the legal community, that if we don't act now, we run the risk of giving over to the very companies people want us to fight the ultimate say as to where these towers are placed, including 30 feet as opposed to 60 feet.
And there have been cases in Virginia where antennas were denied, where the court just said, nope, it's a denial of service, it's approved as submitted. So you had no opportunity to then tweak it one way or the other, or to move it, or to do anything. I mean, this ZTA applies what the council thinks the rules should be going forward without some of that risk. By the way, the executive has promoted the idea that there's a high risk of state preemption as well. And one of the things about state preemption is being a creature of the state that would be more profound than federal preemption. With federal preemption, if there's a taking, we can argue a taking, we have a taking claim against the federal government. We would not have that type of claim against a state preemption. And I've never served in the state legislature. I don't know the odds of going forward, but it was certainly introduced last year. The industry has certainly put forward a particularly virulent preemption draft. But if that does go forward, and it is more likely to go forward without our action than with our action, if it goes forward, you have nothing to say.
I'll defer to my former state delegates, so the view with respect to that, but even under Mr. Katz's proposal, he's contemplating something in February, which would be well before the end of the session, and I can't imagine that we wouldn't be in a position to act before then if necessary. But
So I just on that, just on the calendar, the timing of that, typically the deadline for filing legislation runs at about President's Day weekend. So if you had a process in which you were looking at something in January, you made changes, you'd have to have another public hearing, you'd have several days, you'd have a work session, you'd have a council session. The likelihood that you could get all that done before the filing deadline.
I'm not worried about the filing deadline. I'm worried about action.
Right,
So
but
bills could be introduced, bills were introduced last time, and then they were shelved. Okay, so it isn't, the filing deadline does not dictate this council's consideration, in my judgment, okay? As long as we got our work done before the bill was finally acted upon. And this would not be a bill that would be acted upon early in a session, in my judgment. But we've got 2 other state delegates here, so I just personally don't see that as the ultimate driver. I do see the question of what can we gain by postponing? And that isn't clear to me either. And I say that with all due respect. I don't know what we would learn. And so part of that, Mr. Zients, is do we feel like there is anything more to be learned in this process? Are other jurisdictions considering other setbacks? Are other jurisdictions considering other approaches to this that we would benefit from knowing as opposed to being at the front end of this process? And so how would that alter the consideration of this issue in your judgment, and others, please speak up?
Every jurisdiction is subject to their own geography, and people get solutions that fit them. And one of the things that people have pointed us to is Ocean City, where they basically allowed cell towers in the rights of ways, except in the single-family residential areas where I think council members tend to live of Ocean City. That is, they prohibit it in the residential streets of the single-family zoned area. Now, that's interesting because if you look at the geography of Ocean City, most of it is on, along the major corridors, and these areas of housing enclaves can, for the most part, be served from immediately outside those areas. And by the way, you have water on one side too, but you can serve these areas because of the geography that way. So they're
not effectively denying service.
It's not right. It's not effectively denying service. And by the way, they're looking back at their standards now that they have some experience with the cell towers, other places to look at putting them in some of the residential areas as well if they need be. I think Gaithersburg is always an interesting look, Mr. Katz. I've heard of it. Gaithersburg allows, by franchise agreements, antennas on Pepco poles in their rights of way under particular standards, and they have a ton of design standards, and it's about 120 pages of regulations. But the core of their zoning, by the way, they
do we have design standards? I'm just curious.
Oh, we do.
We have design standards.
To the extent we say same color, same type of design, and we also allow the hearing examiner, when it's a conditional use, more discretion to describe something that would be conforming. But one of the things Gaithersburg does is to prohibit in residential right-of-ways cell towers in those roads. What they allow is antennas on single-family houses. So it says, yes, we don't want them in our right-of-way, but cell companies feel free to negotiate with our homeowners for them to put it in their attic. And that way, it keeps a private use on private property. That it hasn't resulted in any cell towers yet, but it is a completely different approach.
And is it an approach that the county looked at, Ms. Nurmi? And if so, I mean, what's the pros and cons of that approach? Because, you know, we're now being asked to rule on something very specific that does not include what Gaithersburg did. So why is is your model better than the Gaithersburg model?
Oh, I can't say that it's better than the Gaithersburg model. It's different, but when residents told us they wanted greater setbacks, we increased the setbacks, and so allowing them to put it on their homes would not be greater setbacks at all. So we were taking their input into account, and we increased the setbacks in the residential areas. They're 10 feet in the commercial areas, and so in the residential areas, we heard what they said, we increased the setbacks, and so it really didn't occur to us to give them the right to put cell towers on their house because they said they wanted greater setbacks.
We also, as a response to the June 2017 meeting, there was a request that we also expand the prohibition so that they could not be placed on townhouses, and that was added. I also would add that in the city of Baltimore, they allow, city of Baltimore owns its utility poles, and so they allow the placement of those antennas on the utility poles, and there is no setback requirement to use those poles.
No setback at all in Baltimore.
Correct. So if the pole is there, whatever goes on, it uses the pole that's existing.
Including in residential neighborhoods, sorry.
Yes, yes.
I think we got that.
And then,
Good that you reinforced it.
and then I just want to point out on the design standards that we drafted those standards. As part of the FCC rules, you have to have those things in place and in writing. But what we've also is that where the county owns the streetlights, we have more say in the design of them. The FCC, that is a challenge. The FCC is suggesting that the public right-of-way also includes anything that the county government installed in the right-of-way. And so that in addition to the right to use the right-of-way, you should also have the right to use all the county property installed in the right-of-way. But by having the ZTA in place, it gives us the ability to be at the table in the design of what these things will actually look like. We have meetings that are scheduled right now to try to work out some of the technical features of those, and we intend to go forward and present some designs to the public so that they can have input into what the county has approved. And that's similar to the way that the county for streetlights right now, we have about 6 different types of designs and specs that are available.
And what percent of the poles that are at issue are county streetlights?
There's probably about 40,000 out of 70 that are county streetlights.
So 4/7 of the 40,000 out of
Actually,
70,000?
I'm sorry, I misspoke on that. There's 20,000 of them that are the county streetlights.
Out of 80,000?
Out of 70.
Okay, so that 2/7 of the poles will be subject to our design criteria?
Yes, however, it's hard to look at it as an average because in areas where you have underground utilities, the primary thing that you would use is the county streetlight. So in more than half, geographically, it's probably by land mass, I'd say that it's 60% of the county has underground utilities. So the county poles are the primary piece of pre-existing pole that you would use in those areas. And then it's also possible for the county to be working and looking at the design standards. Part of just to say it for quickly, the industry is developing various antennas and equipment. And part of what they're looking to figure out is, in the place that I want to go to, what's the size and dimension requirements? So the fact that Montgomery County has something means that they're going to go to the equipment fabricators and say, you've got to get something that meets these standards. So by being at the table now, we have the ability to drive those discussions. At some point, they're going to have a catalog, and they're going to try to come in and say, well, this is what we've got, because we can't keep manufacturing different things where we go. But what we also would say is another benefit of passing is that other jurisdictions in Maryland have come and they are waiting to see what Montgomery County is doing and looking to adopt the same thing. Prince George's County, Gaithersburg's had that conversation. We're having that with other ones. So what we're also hoping is that the standards are what Montgomery County had done, and similar to in other legislation where when the state comes in later and there's a little true-up, what we've done can be the standard.
So my final question goes to a statement that was repeated during the public hearing several times by a Verizon president that basically said, you don't need to have every 60 feet, you don't need to have every 30 feet, you can have it be 1,000 feet. The technology is changing, it's not necessary for you to do this to your residents. How do people like my colleagues and I take that in and know what to do with it? And so, your thoughts?
So and this is one of the FAQs that we did try to address this. You're looking at different forms of wireless service. So just like you have in your house, you have Wi-Fi that's wireless, but that's different from your cellular service. You right now most likely have a fiber that goes from your street and into your house and provides you some form of cable modem service for internet. Fixed wireless is a method of, instead of having that fiber from the pole into the house, that has potentially the ability to travel longer. It does depend on terrain, and it does depend on tree coverage. And so those signals can travel farther. If you're talking about the phone that you carry with you and you go outside of your house, or sometimes you make calls on it inside your house, when it's not connected to Wi-Fi, it is using a cellular signal. That signal does not travel as far. So both things are true. Some signals you can use the technology, and it gets best to think of as 5G is a tool. There is some spectrum, but what it really is all about is, how do I get a gigabit wirelessly to a mobile device? And there are many different ways to get there. And that's what it's doing. And from the FCC's perspective, because this has also come up in the hearings, we cannot say, well, you could get it using a fiber to the house, so you don't need to have it wirelessly. Or you could get it from one carrier, so you don't have to have it. The court challenge will come because you will have one carrier who will say, I have this mode of doing it, this is where I'm at, do your rules prohibit me from providing service? And the ZTA is drafted to avoid those and to withstand those challenges.
So even as you say, if there's another technology that could provide similar results, if we deny a company that requires 30-foot, 40-foot, 60-foot setbacks in order to work, then you believe our county would be vulnerable on potentially vulnerable on a preemption grounds.
Yes, and I think that you should also, if you just think of it the way that if you come to a judge, we've spent 2 years on this, it's somewhat complicated.
Yeah.
When you go to a federal judge and they've got law clerks, they're not going to sit there and read a primer about a lot of this stuff either. And we've been involved in 3 of these court challenges. So if you come to a judge and you say, well, there's all these poles that are out there and the county's made 90% of them available. Does that have the effect of prohibiting services? And I can show you that in the 10% that we didn't, there was an alternative. I feel good about taking on that case. If we come and we say that, well, of all the polls, we've only made half or a third available, and then you have a case, the odds start to drop. And the likelihood that a judge looks at that and says, but wait, you said you can't use 60+% of the polls, and then you've got challenges of who's already on there, and there's other equipment and there's other things, then I don't feel so good. So that's partly why when we picked these standards, we did site visits, we did tests, we did analysis, because we wanted to find it in a managed way, but we wanted to withstand and I feel good about what we have submitted, that I'd take my chances. I'm not the county attorney, I'm not the one paying for the litigation. But if you just ask me, I feel good that we tried to make sure that we did not prohibit service, but the big thing is that we can retain the public hearing process in the zoning, in the places where it was most likely to be difficult to blend into the neighborhood.
Well, let me just say, as again, one who represents the quote limited use areas, they're not happy. Okay, so the down county that Mr. Hucker and I and Bethesda communities and the areas that are being targeted the most for this technology are people that are very nervous with respect to this, which is why I was prompted to offer the amendments that I've offered, because they don't feel like their needs have been adequately addressed to date. So just know that while there's a lot of conversation about the areas that need new poles and blah, 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 I'm sorry, there is no part of our county where this is targeted for that's feeling real comfortable.
So the only piece I would add on that is one interesting thing that came up in the analysis that the mapping that the park and planning did, is that by the county establishing that there is, in the areas where you have the wooden poles, there is a minimum of 30 feet. There is no conditional use to allow something shorter, some shorter distance to that. And it was very surprising to me that there are actually a significant number of poles that do not meet that. And so roughly, in some of the ones that we did, there were 40% of poles that you cannot use because of that, and we did not allow that in part to kind of address that.
Understood. I thank my colleagues for indulging.
Thank you. That was a helpful dialogue. Mr. Rice.
Well, thank you very much, Mr. President. This has been some really good discussion that I think has been incredibly helpful in trying to help us to get to a compromise. And I say that because as part of the public hearing testimony, I was referred to by one of the speakers who said that Councilmember Rice had said that he felt confident we would be able to get to a compromise. I believe that that's there just as we did for our commercial CTA, that we can find a compromise here with residential as well. I do want to start off by saying that I support Councilmember Berliner's amendments. I think that they're very well intentioned and will certainly get us more confidence from the community. I will just say that I've heard from other members of the community who are small business owners who aren't small business owners in commercial space, but in residential homes, who are very concerned about signal service, who are waiting for this service to come that's going to give them options. And I'll tell you something that's very interesting about how technology has changed our society. My father does not have a home telephone. He has his mobile phone. He doesn't have internet service. He uses his mobile phone to do everything. He pays his bills on his mobile phone, right? This is something that I want to make sure people understand is part of the reason why the industry is moving in this direction. It's not just about the person watching the kitten videos. It's very true. There are people who do it for that, but there are other people out there who are high data consumption users, people who are app designers. It was one of the people that I talked to last night at an economic development forum, a young man who's an app designer, and he's like, yeah, I just can't get enough power in my computer to do all the things that I need to do. Entrepreneurial spirit, somebody who's out there who's is on the cusp of doing all these great things and is going to have the next Waze app or whatever it is that we're going to all download and utilize, and they're depending on the industry moving in this direction. So I want to just put that out there also, because as we talk about folks who are very concerned, and we heard it in the public hearing from some of those folks too who are talking about the other side. So I want to make sure that we have that balanced view that's here. Now, that being said, I agree with the comments about the Tower Committee. There's certainly, it's kind of a mystery out there to folks. Folks don't know and understand it, so the better that we can do about ensuring that there is, and again, I understand what it does and what it is right now. If we need to revamp that, let's look at what something like that would look like to ensure that we have input from everyone to get us the best kind of procedures and process that we want, similar to all the other commissions and boards that we have out there. And yes, I know Councilmember Leventhal's ears are probably pricking up when we talk about another commission, but at least it already exists, Councilmember Leventhal, so you don't have to get nervous about creating another one. But the other piece of this has been a conversation and a criticism about enforcement. And so while I know, and we've been told by council staff and others, that we can't incorporate enforcement into this as an amendment because it is a ZTA, and I certainly understand that, I just want to publicly state, and I've had this conversation with some of my colleagues, that I am ready and willing at any point to introduce, in partnership with some of the other folks, a bill that deals strictly with the expansion of enforcement enabling opportunities for our department so that we can address that. So that's there. So basically what I'm saying is that I've seen the amendments that have been presented to us in advance. I support them. I think that they make sense. I think that we need to move forward with a companion piece of legislation. It won't move at the same speed because if it's introduced now, it won't get passed for a while, but certainly will still be passed in terms of the enforcement aspect. But I also don't believe that we need to delay this process. If we have folks who understand and are identifying the issues that are before us, let us address the issues and make this a good bill. Let's make it one in which we don't incentivize folks to say, well, Montgomery County, the largest jurisdiction in the state of Maryland, hasn't acted, and so therefore, is that indicative of something? And I'm not saying it is. It's all going to be judgmental. I mean, Councilmember Hucker and I served in Annapolis. He served there longer than I did. But I can tell you that we both have the same experience in that folks' motivations are always different. It always depends in terms of what it is that they're going to do and what they're going to decide to do. I will say that if we have legislation that's passed, and Councilmember Hucker, I don't want to speak for him, but we just had this conversation and both agree, if we do pass legislation, we will likely be grandfathered, and so it will make it easier for us to then not have to worry about what the state does in terms of its moving forward. While it doesn't have to be, so a timeline process would be before the General Assembly session ends. My point would be that nothing changes between now and March, so we don't need to wait. You know, let's send a signal and say that, yes, we're able to figure this out. We're able to come up with a great compromise, and we can be a model. I mean, look, you know, it's not as if Montgomery County doesn't lead in everything else in the state anyway. It's what we do, right? It is. I mean, when I look, I serve on the Chesapeake Bay Water Resource Policy Committee, our whip, you know, we're in front on all of the issues. We never backed down and said, sorry, this one is too tough, we're going to punt. We're able to figure this out. And there's a reason why we have very, very smart people that live here, very, very smart people that work here. We're able to get it done. And we have an engaged community that cares and makes sure that everybody is well represented and that their issues are represented. We have the perfect storm here. So if we have the perfect storm, let's actually make it work for us and come up with some good legislation. So I'm anxious to hear from my colleagues about some of the other amendments that they have and how we can best roll those into the existing ZTA. But, Mr. President, I just want to thank you also for your leadership and really trying to get us to a place where I think we'll have something that actually balances the needs of all residents in our community. So thank you.
I can hear you now. I appreciate your comments, right on the money. Mr. Elrich.
So I have a bunch of questions. Unfortunately, they're not repetitive, I don't think. First thing I want to say, I mean, I went on Verizon's site because they talk a lot about Sacramento. I looked at Sacramento. Sacramento, the model, has 200 cell towers for the entire city, and what they talk about is the importance of providing the cell towers in places with high density. And so if you look at the map of the distribution of cell towers, there's whole parts of Sacramento that have little or no cell towers. There is no ubiquity in cell towers everywhere. Cell towers seem to be tied to the commercial areas in Sacramento, not to the residential neighborhoods. And if you read the same stuff on the Verizon site, they talk about how the system is going to be a combination of 4G LTE plus 5G. It's not that 5G is replacing 4G, it's a combination of these things. And they go on to say that the 5G is best suited for urban environments with density. And then they don't talk about the suburbs. They don't talk about the neighborhoods, which gets to something that I've always wondered about, is why are we messing with Fife and other places that can be served with 4G, and instead talking about 5G out there? Because by Verizon Zone, apparently the way they describe what this is best for, it's not best for suburbs. It's not needed. It's not a high-density thing. And they seem to be happy with Sacramento, which kind of made me wonder why we aren't happy with the first bill we passed, which dealt with the high-density commercial areas, because it doesn't seem all that much different than what their favorite model city in America did. And if they're not fussing about this and saying we have to preempt Sacramento, then I don't understand why we have to do something that's a whole lot different than what they put out there. And so just at a fundamental level, I've never been satisfied in this discussion is the push to go out to areas where it seems there's not the density of use to justify it. But then I wonder about some of the things they talk about, because I think some people said that you're not going to extend the towers where there's no demand. Well, how does that work with cars that would require constant connections if they're going to be self-driving cars? I mean, I almost feel like, if this is going to be something where it has to be ubiquitous, why isn't it required to be ubiquitous? Which I don't really want to do, but it seems if you're arguing this is necessary for self-driving cars, the economics of this indicate that it'll only be in places where there's demand for it. So I keep feeling like I hear arguments that are disconnected from each other, and that's why I'm having a hard time understanding what the right thing to do on this thing is. And Nancy's right, I'm an early adopter. The only reason I don't have the iPhone, what is it, Max X, is because I can't get there at time in the morning before they sell the darn things and they won't hold them. So that accounts for my technology lag at this point. But I had some other questions about this. And so first is, if you go with the 60-foot that has been suggested, it seems to me that almost everything fails the 60. If you're in the R60 and R90 zone, the setbacks are 25 and 35 feet respectively, and that gets me to the right-of-way, and maybe 10 feet beyond that's a street if there actually is a right-of-way. So almost nothing's going to be 60 feet away from a house, unless there are no houses on the other side of the street and only houses on one side of the street. So if there are houses on both sides of the street, how do you ever achieve the 60-foot? And so isn't it default that you're going to get towers at 30 or 35 feet?
There may be some areas where it doesn't, where that is true, in which case it would allow at least a 30-foot setback. And again, remember, we're trying not to, in this CTA, create more poles in the right-of-way. It would be a replacement pole where the existing pole exists. But yes, there are some cases where where a 60-foot may result in what will be perceived as a denial of service.
Okay. Of the apps you talked about being in process now, are they all small cell apps?
Yeah, those are as so far as I know, I'm getting that from Ms. Herrera, but as far as I know, those were the small cell applications. There are some, there's at least one major tower application that's in now.
If a person, I mean, there is no 5G now. So if I was putting in something to fill a void, it would be 4G. For the moment, it would be.
One of the things I don't talk about in this is 4G or 5G. It is the provisions of wireless technology, wireless communication. I don't know the generation.
No, I agree, but my point is only that we've been told the distances of the broadcast are shorter for 5G than they are for 4G, which is why they can't be 2,000 feet apart. They have to be much closer to the target.
But it's also for that shorter distance is what's called DAS, distributed antenna networks, which also require shorter distances. But that's why none of this talks about technology. It talks about a wireless facility and setbacks.
But if a company does both 4G with towers and they have DSs and everything else, is it a denial of service if you say, since you have the towers and you use the towers, that in this area it's more appropriate to use a tower than to use the small cell?
Well, number one, we always try to co-locate. We don't like more towers than we need to have. Right. We want to minimize that. The other thing I suspect that that some people have done is allowed taller towers. Remember, these are very short. The FCC has been talking about things that are 50-foot tall. The state preemption bill is 50-foot tall. Those would really be obtrusive in an area where the height of the house is 25, 30 feet. So it's been careful on regulating on that basis.
So what if a company comes in and their design of poles is different than pole designs that somebody else might use? Suppose somebody's using poles where they've actually internalized the equipment inside the pole itself, and somebody else says, well, my poles, we don't do that. We have the ugly, hideous boxes next to the pole.
Well, we're commanding the equipment at the base of the pole in this as part of the design. That is one of the requirements in here. So we expect that that equipment box to be at the base of those.
At the base or in the base? That's different.
I think it's in the base. I think it's part of the base.
Yeah, it is part of the base in the pole, but to that point about those designs is that where they are our street lights, we have the ability as the proprietary owner to have more say about that. You can't get the equipment inside the wooden pole. So
No kidding,
it mostly applies to where you've got freestanding street lights, and we have the ability to do that. I just wanted to point out on the point of where you said about the denial of service, the FCC has teed up that issue. And they have specifically in their last order, I don't believe that the FCC, they're trying to sit there as though they're a court. Some circuits were in our favor, some circuits are not, and they're sort of suggesting, well, we want to deal with the ones that supported local governments. I don't know that that's going to withstand their ability to do it. However, they are, as the expert agency, saying that when you look at what service is, it should include these different forms, and they have clearly teed that up. However, I think that by the county taking action and working on it, there's a lot of things to suggest that the industry is able to offer those services at lower elevation, much lower than 50 feet. And these things work in concert. So I think that it sets us up in a better position to be able to say that we have actually provided a way forward that allows that technology to work and that you don't need to have that much more height. And just to follow up on Councilmember Rice's, just for the moment on that, you also have neighborhoods where even though the county has Verizon, Fios, and Comcast, you have some neighborhoods in which you have HOAs, in which they didn't want somebody else digging up the yard. Or you have an apartment building owner who only picked one. So by being able to offer a wireless service, so Verizon may have, here's a wireless alternative to Fios, and then here's a cellular Verizon service that's able to offer. And that means that potentially, as we have a lot more home-based businesses, and those businesses have a lot more technological needs, that people actually have more ability to get competition, and the HOAs get the benefit that they have less fiber and digging up in the yard.
So can you compel only one light? Can you, if a company says they want to put in their own, they want on their own pole, they don't want to co-locate, can you compel co-location? And can you compel the owner of the tower or whatever the antenna structure is to co-locate somebody else's antenna, so all these things are compacted?
As if the county is operating as the utility pole owner, our ability to say about which poles you can use if there's an alternative, our ability to potentially say, okay, we have some equipment on there and we'd like this second company X to come in and also put their equipment on there. There may be technical reasons of why you can have only so many antennas together, but I think you're in a better position than is the county as the regulator in the right-of-way. I think that that would be a tougher argument to make.
But we've been successful at getting co-location. And the design specs in this ETA allow for 3 antennas at every location. There are 4 national providers right now. It's unknown if everybody wants to be here too. So we are encouraging co-location.
So you're saying a person can't say, I don't want to co-locate, I want my own tower?
Again, if we're dealing with our poles and our right-of-way, we could say no, if there's another alternative to go to.
If it's not, and they can't put their own stuff in our right-of-way?
That's correct.
But I would also point out that you can have co-location by the same company. As you pointed out, 4G is not going to go away. So you'll have 4G, you'll have 5G, you can have other things. So you may have, it's not 3 companies co-locating on there, but it is one company that's co-located 3 types of equipment as well. And the point, again, of using and creating a process where there is limited use, particularly for those poles that are taller than 22 feet, is that the county has been successful in 90% of our current applications for macro cells were co-location sites. And the point of doing it is that we, and somebody asked me today, we don't have a process to allow new poles to be placed in a lot of these areas, because the purpose is that we've already got a lot of street furniture out there, and we want to leverage and use that and have a process that drives people to it.
If I may, to your point though, Councilmember Elrich, if you're putting it on, the reason the discussion is focusing on a pole or a light pole is because those are things that there is a right to have in the right-of-way. If you're talking about somebody coming in de novo to put in a tower in the right-of-way, you can't just do that. That would require, first of all, it would require a franchise agreement in order to do something like that, and the county council holds the ultimate control on that.
What happens if your light poles aren't close enough to provide adequate service? If they say that your poles are too far apart for us to provide service, if you don't let me put in a pole, you're denying me service?
Having spent much more time looking at these poles than I ever thought I would, a lot of these poles are 150 feet apart. I think that is very unlikely. Having looked at multiple different neighborhoods, I have yet to find one where you couldn't find some alternative. I do want to point out, though, on that, the point about coming in, yes, you would have to have underlying franchise. However, the FCC order, to me, seems to suggest that if you're coming in and putting in a new pole for a small cell, which is 28 cubic feet of equipment and less than 50 feet, that you should have a right to do that. And by the county having a process where we've said, well, you can come in and do it, but you've got to do it in a place where you're replacing something that exists, seems like a good legally defensible way to say that we're not adding to the infrastructure, we're not prohibiting you from providing service, but we're also not just adding more poles.
I'll just say, I mean, I drove through some neighborhoods because I was curious about the pole question, and I saw neighborhoods where poles were nowhere close to 150 feet apart, where they were pretty sparsely distributed through neighborhoods. I won't say all neighborhoods, but there are places where they seem more at corners than they seemed any place else, and there was a lot of distance between the poles. So I didn't, perhaps there's no uniform. I just, you know, I didn't take my ruler out and measure it. I also don't have the iPhone app for pointing at something and getting the distance yet. Do you have that?
5G app.
Yep, it does exist. Never mind yet. I will get that from Mr. Hucker later. So I'll just say my biggest issue with this is probably not unlike Mr. Katz's issue with this, which is I think most people in the community have perceived this as a fight among a couple of really, really indignant neighborhoods where they feel they're being imposed on. And I recognize that you've had a bunch of meetings, but I think a lot of people have no idea what we're about to do and no idea whether you're talking about, as some people say, thousands of poles in the community or, like Sacramento, a couple hundred poles. And I'll take bets that it's not a couple of hundred poles because Jeff's already got apps for 120 sitting there. And I don't think anybody's laid out, none of the companies have laid out where they plan to go here. You know, what are they going to do? And so I think a lot of residents, from near as I can tell from talking to people, don't have a clue about what we're about to do. And that worries me because I think when things start popping up, people will say, and why is this happening and why didn't we know about it? And they're going to be really upset. And it may not be over health reasons. They're allowed to be upset for health reasons, but nobody can discuss that. But they may be upset just because they're bothered by the presence of these new poles and the way they look. And I'm trying to picture what 28 cubic feet looks like in a pole because I'm picturing, what is it, 7 by 2 by 2 with round corners. That's not exactly a nice, slimly designed pole. I mean, yeah.
Circle 29, we put in some examples of
a
cubic
28-foot pole, of a pole with 28.
No, you were asking about the
Yeah.
equipment box.
Yeah.
And I believe the limit that we allow is 20 cubic feet, not 29.
It's okay.
So if you look on Circle 29, it's that 3 carrier box on the bottom of a pole that would be allowed. And that would be 26 by 26 by 48.
So 2 feet, 2 feet, 4 feet.
Right.
It's not a very nice looking box in black and white.
Remember, I'm from New Jersey. I can't make that determination.
But that is the point of actually engaging in the design meetings now and looking to see what are the best things, what are the possibilities, engaging with equipment manufacturers. We are at the cusp of which these things are being designed now, so being at the table gives us the ability to help drive that conversation.
I guess I'm kind of inclined to think we could do something before the next legislative session. I would agree with Mr. Rice and Mr. Katz on that. I think this may well be solvable, but I'd certainly, I'll use your words, Sidney, charrette. It's hard to say it. I want to say it the other way. But yeah, we could, you could probably do some charrettes and actually put people to the table, make them draw out and show people what this is going to look like in a much more down-to-earth way inside their neighborhoods. And then, you know, I'd be more happy with this if I didn't think we were going to spring this as an element of surprise on a lot of people. I think if, you know, people might say, I really like the service, or I like the idea of the speed. And, you know, there are certainly people out there who want that. I will say that, you know, T-Mobile anyway does 1 gigabit service right now. So if that's the standard you're trying to achieve, it's already been done with 4G LTE. I recognize this is beyond that, but I can actually send the signal from my iPhone to my TV with no stuttering and no latency. So I feel pretty good about the service I have right now. Everybody else may not feel the same way. We had people testify they weren't very happy with their service. But anyway, those are my questions for now.
Thank you, Mr. Elrich. Mr. Hucker.
Thank you, Council President. I appreciate all your comments about the improvements that have already been made to this bill and gotten us this far, and I appreciate all your work in this area, and especially your defense of local prerogative. That's very important to me, as I know it is to everyone here. And I'm also glad to hear you realize we're not yet finished. I don't think this is yet optimal, and I agree we're presented with a lousy situation where it's not of our creation, but agree we should have our own ordinance and maximize the chances we can affect our own destiny in this area. And in that spirit, I believe it's our obligation to make this as good as possible and as responsive to our constituents within the guardrails that have been set out. And unlike Mr. Leventhal, I'm catching up on this issue. I'm not on the Fed committee. I've only had the opportunity to talk to the administration about it late last week, learning this complicated issue as fast as I can. And I've asked one thing for the maps. We talked about showing which poles would be eligible for towers within, if the setback were 40 or 45 feet. I'd still love to see those. Do you guys have any idea when those might be available?
The 60-foot and the 45 setback is available now.
45 is available? Okay, great. I haven't seen that, but I look forward to it.
It's the same link. It's in the one that's in the council packet.
Terrific. Thank you. I absolutely agree with Mr. Elrich's comment that despite the full hearings we've had, I think a small percentage of the folks in this county are paying attention, certainly to the details of this at this point. Having 300 people in here is still a very small fraction of a county of 1 million people, and this is a new area, and I think the concern is only going to grow as deployment continues. So I feel like we have a special responsibility to try to be as responsive as we can. In terms of the window for action, I'm not convinced there's only upsides to being an early adopter among the large counties. I understand the argument that they're waiting to see what we should do. They, I'm sure, will benefit from all your hard work in this area and all the meetings you've sat through. I would like to see us in alignment with some other large counties that are in the position now of watching what we do and working hand in glove with our state delegation. From talking to a lot of our state legislators, it doesn't feel like we're in that position, but they're our safeguard against preemption. And as long as we pass legislation before the state assembly does, and in any case their enactment date was going to be after the assembly, I don't see how we're in great danger of being preempted by the state. I think there's room for improvement in our coordination with the state delegation. As far as the limited use goes, I have, as was mentioned by Mr. Berliner, he and I represent an awful lot of the county where that's envisioned. And I drafted an amendment in this area that I think I want to make a couple corrections to, and I'm happy to share with everybody. But I think the goal that I hope most of us could agree on is that nobody wakes up and finds a tower in front of their home and didn't have any notice about it and don't have any right to appeal its placement. That's a situation I think we could all empathize with and would be we'd be wise to avoid in as many cases as possible. So while I appreciate the committee's effort to put conditional use in some areas with underground utilities, that's definitely better for those residents. I think the unintended consequence is we're offering protections and a right to due process to some people and not others based on the zone they live in. People in all different areas of the county have concerns about this, and without debating the merits of their concern, I have a problem with telling some of my constituents you have right to notice and right to a public hearing, and others that you don't. And it's simply just a function of the neighborhood you chose to live in. There's folks in newer neighborhoods have all kinds of advantages as it is, having underground utilities and newer homes that aren't falling apart and fewer water main breaks and everything else. I think we put ourselves in a very difficult position to argue to tell the folks in our older neighborhoods that have to deal with older houses, older utilities, above ground, unreliable utilities to begin with. Sorry, you now don't have the same right to due process to a notice and to a hearing. I think we need to work on that problem. We just agreed to adopt an equity lens on all the policy that we're going to make here going forward. And to me, the ZTA, as it came out of the committee, only exacerbates the disparities that we have on the ground and doesn't address them. So I feel like we need to move closer to having a limited use, I mean a conditional use for everybody in the county, maybe with some exceptions, but very, very few. I think that the way it's set up, it's unfair and will come back to bite us. I know the concern I've heard is that this is going to create a backlog of hearings that we have to manage. Understandable. As Jeff said, there's 120 applications pending now, and we're expecting 700 to 900 a year to come in.
I think the industry has said they have a sort of immediate plans for about 700, but they wouldn't be done with that either.
Right. So we have to manage this problem either way, to me. We have to hire more examiners or create a more expedited process or something. But to offer a certain set of rights to certain people in the county and not to others, I think is a problem. It's our duty to manage. And I don't think we can just get away with just telling people that we can't address their concern because of this process that we've created that we have control over. So that's why I suggest we retain the 60-foot setback in all residential zones, but allow a setback down to the maximum number of feet, whether it's 45 or 40, that's necessary to avoid a denial of service claim. That's I think a little more expansive and protective to neighborhoods than Rogers.
Why don't we ask staff to, characterize the differences there?
I mean, number one, where the committee is and where I think Councilmember Berliner was to say that you could, if necessary, go down to 30 feet. I don't know if Councilmember Hucker, if you were proposing some variable standard greater than that as a minimum?
The way you had written it up, I thought, was to specifically allow it only in cases where it's necessary.
In cases where it's necessary, but down to 30 feet.
To avoid a denial of service.
Which is the same as Councilmember Berliner's. Okay. In that, the only difference with Councilmember Berliner's amendment is that it applies where conditional use is. No, it's required for where there's limited use. Right. Whereas what you're proposing is to doing this within a regime where there are no limited uses. Everything is a conditional use, but has the same, really the same provision that the committee put in for the conditional uses, which said 60 feet, but allowable down to 30.
To extend that protection everywhere, as long as we aren't guilty of denial of service.
So let me just point out something about the FCC order on that one and the requirement to move forward on a non-discriminatory basis. In the underground utility areas, everything is required to be underground. So to say that there is an additional process that applies because you are asking for something that is not given to others, in the areas particularly where you have wooden utility poles, we do not require a conditional use for Pepco to attach 4-foot transformers. We do not require conditional use when we put up wireline communications. We do not require conditional use when you have slack cables, when you have splice enclosures, and other types of equipment that would be of similar size. We leave ourselves open to risk, and this was specifically addressed in the FCC order, that if you are now treating different entities using the same facilities differently in the right-of-way, and you're coming forward and you're saying, I'm going to treat wireless in addition to all the other things that we already have in place differently than we have it. In addition to the other things about a conditional use is that in the limited use is intended to be a bright line test. So if you meet the standards, you can move forward. Conditional use is the hearing examiner can say no. So now I've said in comparison for this one industry to other ones, that there is an additional one, an additional conditional use, and it isn't something that applies to everyone, I think puts us more at legal risk. In addition, I mean, there's a spot that we looked at where the county and Tacoma Park and the county line sort of come together. There's 54 poles there. There's only 3 of them that meet a 60-foot setback. And I didn't go back to look to see whether those already had equipment from Pepco that was on there. So if I had to go before a judge and say that I created a process that said, if you're not going to use one of those, you have to justify why, and the burden of proof is on you, as the Berliner Amendment would do, and you have a process for doing that, that's one thing. But if I'm now going to say that you have to prove that, and I'm not actually giving you a path forward that you could come in and still say it, and the hearing examiner could still say, no, I don't, I think that's a riskier legal strategy for us. And I think that when you look at, in looking at the mapping data, and you can take a look at it, when you look at the significant number of poles that do not meet a 60-foot setback, and the ability for a provider to come in and argue in court that we are effectively denying the provision of services that support the new iPhone and these other types of things, I just think that that puts us in a much riskier position. And again, I live in your district. I recognize I live in a spot where I've got a couple poles out there and things on there. I think the challenge that you have is the pole is already there. There is similar equipment that's put on it. So it puts us in harder, well, I understand and I appreciate what you're saying about that. It puts us in a much harder position legally to defend it because it's already there.
Mr. Zions, do you have any thoughts on our legal risk?
I mean, it's making it a conditional use where the pole exists already and it's a wooden pole puts the hearing examiner, I'm trying to find the conditions for approval, if somebody could find that in 2 seconds, in a strange position, because the finding that they have to make is that the facility is compatible or can be made compatible with nearby residential by the use of screening, coloring, stealth design, visible mitigation options after considering the height of the structure, topography, existing vegetation, and environmental features. That's impossible to do when you are doing it with a replacement pole because the pole already exists. You're not going to put vegetation around the pole. It's already there. All you're doing is moving it 2 feet and possibly making it 6 foot higher. I forgot the height. 10, up to 10 feet higher. But it's hard to mask the visual intrusiveness of that existing pole.
Okay, I don't know if I have any more questions. I have other comments on enforcement and other things, but that's another time.
No easy way out. All right, Mr. Katz.
Thank you, Mr. President. So I understand the 120 applications that are existing right now. When they applied, what they were applying for was, what was the setback that they asked? How it exists today?
So so at the time, if you had an antenna that was smaller than 2 by 3, we said that you could place it on any existing structure so long it was 60 feet from a house and at least 15 feet above ground.
That's as the law exists today.
So what we changed that so that you can only put on the specific, what it did is we changed it so we closed a loophole. Because if you put on larger equipment, you weren't subject to that setback limit. The other thing is that when those applications came in, is that these were for co-locations on an existing structure, and the structures needed to be replaced to be stronger or taller. And that's what led them to be that they would be new structures and subject to conditional use, which has a 300-foot setback. So if you can use the pole without having to replace it, and the pole is at least 60 feet back, you could use it. If you have to replace the pole, it would have to be 300 feet back, both of which create problems for us to comply with the requirement not to prohibit service.
Okay, but I guess if someone applied to do that, which is what they've done in the 120 cases, and we said, yeah, you can do that, why is that denial?
Because we wouldn't say, yeah, you can do that.
Right, so we would say you can't do it under our law, under existing law.
Yes.
And our reason?
After a conditional use.
Okay, and the reason being that we wouldn't allow it would be for what reason?
Because they wouldn't meet the setbacks.
Because they wouldn't meet the setbacks, I see. So, and then what is the fine for if they don't remove something? And I know that that's something that we were going to discuss as another ordinance.
It's a new provision that's been added in, and in the zoning ordinance, what is it, 500 or 1,000? But the more important thing is that we would have the ability to go for an abatement order. So we can, it's two tiers. One, we would impose a citation, and two, we would be asking for an abatement order. The abatement order is to get the compliance, really. The fine is, it might be more of a, maybe to try to get their attention. Maybe it would cover some of our costs for recovery for taking enforcement action. Ultimately, when you have somebody who's really, really difficult, it does get to be painful, but what's the? 500. 500. So it's 500 per citation.
And could we say that if something is not removed after whatever time frame we feel is fair and worked out, then at that point, they could not put up new poles until the old poles are taken down? Any additional? Mm-hmm. Is that part of something that we could do?
You're dealing with the authorities of the Public Utility Commission and the right of PEPCO to provide service in the right-of-way.
So these would all be on PEPCO poles, is what you're saying?
Yeah.
Yes. So what we've done, though, too, to try to really get attention and there have been cases where we've really needed to, we literally have gone out every single day and issued a new citation, because every day that it is not corrected is a new violation. And when we've had a very difficult situation, we will do that. We go to court, we get the abatement order. We go out and we enforce the abatement order, and if we can't get compliance then we would have the court would have a show cause hearing on contempt. So, so that's a fairly powerful tool.
And just so I understand, if it's a private street, and not that I'm no fan of private streets, but if it's a private street and it's a private light on that private street, street light, then the homeowners association, or whoever owns that private light, would have the authority to say yes or no to, I'm asking it as a question, to any unregulated utility that would want to come in there, right?
God and Cliff Royalty know that I don't advise homeowners association. But barring that.
Yeah. Well, we can check with Cliff. I don't know about other people. Yeah, go ahead,
You're dealing with private property. Zoning is a permissive opportunity. You can follow our guidelines. or you could not do it. It doesn't make you do anything or
Okay.
require you to do anything.
But you still would have to get a permit from us for that. It would not be a right-of-way permit, but it would be a permit.
Okay. And though, as I mentioned casually in the beginning, though I think we should be taking another breather on this thing and actually get it better, but in the fact, if we are going forward, I'm saying if we go forward, then can we require someone before the 120 days or whatever the FCC this week has said how fast you have to do something? Can we require before someone files, before the industry files, that there be requirements that they have a charrette with the public?
You mean at least a public meeting?
Public, whatever you want to call it, a public
I
discussion?
mean, we certainly have those requirements with applications for preliminary plans. The difference is I'm not sure how it would be interpreted on the shot clock basis, on whether they would start measuring that shot clock from the time that we required that application. I just don't know that answer.
And that is something that the FCC in their last order that they were specifically looking at were what they characterized as an end run around the shot clock by having other requirements that needed to be met before the application was filed. So I think that we could take a closer look at it, but I would be very concerned about that.
Thank you.
All right, Mr. Leventhal.
This has been a helpful dialogue. I would renew my request to my colleagues. Well, first of all, I want to ask a question of the Council President. When do you anticipate this will come before us for votes? Do you expect
2 weeks.
2 weeks from today?
Correct.
And is it your expectation that after today's work session, there would not be another work session, and that 2
Correct.
weeks from now, that would be our last discussion of this topic? Okay.
Yes.
Okay. If Mr. Katz is going to pursue what is in effect a tabling motion, I'd suggest with great respect and friendship that he do it. And then we can get that out of the way. And I don't know if it's in order to do it today, or if there's no votes today. I mean, I think a tabling motion's in order at any time, and it's non-debatable. That would then clear that out, so that all of us, myself included, can get our minds around what we're actually going to be voting on. Mr. Hucker said that he was going to propose that we go back to everything being a conditional use. I'm persuaded, based on what I heard both now and previously, that that would be interpreted as denying service, that would just be such a time-consuming enterprise for the wireless companies that they'll take us to court and we'll lose. So I wouldn't vote for that. Not because I want to avoid double negatives. I do have sympathy for my constituents who are feeling anxiety. I have sympathy for them. And I'm very open to reasonable amendments that go more in the direction of, as in Mr. Berliner's case, providing notification, providing opportunities for input. If we can increase the setbacks and sustain that in a court challenge, I'm open to those kinds of things. So this is complicated stuff. And I had the impression that Mr. Hucker had more amendments than the ones that he just alluded to now. So what I'm going to do is I'm going to renew my request to my colleagues to show your cards as early as possible. If Mr. Katz is going to offer a tabling motion, let's get it out of the way, okay? And then we don't have to spend more time talking about this complex topic, which only makes, those constituents who are paying attention to it, which is not many, really mad at us. So if it's the will of this body, I'm not going to vote for it. But if the will of this body is, let's not take it up now, deal with it in 2019 or 2020 or 2026 or just not now, then let's find that out soon so that we aren't debating something in advance of a tabling motion, which you're not supposed to do. If there's going to be a tabling motion, it's non-debatable. Get that out of the way. That's the first thing. Second thing is, Mr. Berliner's clear. We understand his amendments. The county executive says they're fine. I think they're fine. Mr. Hucker had a couple of suggestions just now which the county executives people think are problematic, and they sound problematic to me. If council members are thinking about other amendments, I'm not planning offering others, but I'm open to voting for others. It would just really, really be helpful to know what those are, because this is complicated stuff. So if you have others, Mr. Hucker, maybe if we could hear what those are, or if other council members are going to do that. Because if we're going to end today It's already after 4 o'clock. We're very rarely in session this late. And we're not going to take it up until 2 weeks from now, and then we're going to vote. You know, we really need some time to vet and understand and get the different points of view on different amendments. So if we could maybe achieve a finite list of amendments that are to be offered, that wouldn't have to be now in open session, but say 1 week before we vote. You know, if we're going to, I would just ask my colleagues not to present us with any surprise amendments, because we won't be able to make wise decisions in that context.
Thank you, Mr. Leventhal. Really appreciate your points there. And it is definitely my hope that anyone who wants to offer an amendment will, first of all, show their cards today, as you've said, and then secondly, immediately prepare any text so that we can have at least a full week to discuss and deliberate. I think we need time, and it takes time. So, you know, we are having discussion today, and then I'm sure we'll have additional discussion, but it should be focused and to the point, and hopefully people will know going in where they stand on issues.
And if I may, Mr. President, just last point again, it's so important, I'm going to repeat it. If there's going to be a tabling motion, then let's be clear about that, and then let's not waste our time on anything else. If it's going to be tabled and put off, let's know that, let's do that, and move on to other business, because this council has a lot of business before it.
Yeah. I mean, I would think that the tabling motion would be most in order right now, frankly. But I want to say something about that beforehand. I think it'd be a devastating decision to table this. I think that we won't have time to enact any legislation in the new council before the legislative process in Annapolis is way underway. And so I think it's very unfair to the next council to make them do this when we've already done it. And the issues aren't going to change. The real issue is setbacks. We've discussed every real issue. We know the issues. They're knowable. They're known. And I think that we ought to just tie this up and move on and let the next council, you know, deal with it, deal with other issues. Yeah, we have a queue, and so council members, I will continue through the order that we are currently in, and the next speaker is Ms. Florine.
Thank you. I agree that if we're not going to do this, let's not do it. I agree, and let's have the vote as soon as possible. They'll save everybody a fair amount of grief. But I will say, in response to the equity comment that was made earlier, think about what we're talking about. We're talking about what's a public utility. This is stuff that is supposed to be equitably available to people. Water, of course we have an issues with sewer, but water, sewer, electricity. The reason there are these public rights-of-way, and the history actually of all this is the Bell Atlantic, CNP, whatever it was before then. There was a public policy determination that the community needed access. That's the fundamental issue, access. Now, I'm fine with Mr. Berliner's suggestions. I'm fine with other amendments that help make this more palatable. I'll tell you, my house, I wish they'd put one on the pole that's 20 feet from my bedroom, because I have crummy cell service, and I have Fios, and I have all this stuff. It still doesn't work. I mean, everybody's situation is different. And as we go forward, our residents, a lot of them are working from home. Craig's father sounds like an advanced user of cell service. And I think we don't have a landline either anymore. But everything's changing all the time. And we have an obligation to worry about the people who aren't here, to worry about the people who can't. We heard from a number of young people about their dependency on cell service and wireless internet access. We have a lot of people that we want to encourage to be ready for the future. So, And those people may not be the same people who are concerned about the visual effects of this. In my personal neighborhood, which is within, I'm personally surrounded by wooden poles, there's a lot of junk on it that nobody sees. We're just used to it. It's not attractive, it's not beautiful, but it's there. Nobody notices this stuff. So I think we have to remember what our fundamental obligation is here, which is to make service of this sort available to the public in a reasonable fashion. I don't think there's any new issue that's likely to come up if the next council takes it up. If you don't want to do it, okay. But we've pretty much vetted the issues, tried to find a solution, and really tried to take a lot of things into account. But if you're talking about equity, I think you have to worry about everyone. And that's a lot of people that we haven't heard from, who are all on their phones at this point, probably not watching us, but doing their work and proceeding. So let's agree that term can be used in a variety of fashions. So I hope we decide to continue on with this conversation over the next couple of weeks. If we don't, we can, okay, that's what we are. That's who we are. But I do think we have an obligation to deal with this, and it's hard to load this on brand new council members. Just think I agree that it's unfair.
Thank you very much. I certainly agree. I think most people expect their phones to work when they turn them on, and they take that for granted. I think those are the people we aren't hearing from, as the people who expect us to do our job and ensure that wireless will continue to work. Mr. Rice. All right, Mr. Katz.
Thank you. I know this is going to come as a shock. Mr. President, I move that we table Z 1811.
All right, this is a motion that's non-debatable. It needs a second. Second. Seconded by Mr. Elrich. All those in favor, raise your hand. Mr. Katz and Mr. Elrich and Mr. Hucker. All right, very good. Now we shall return. Oh. Thank you, Mr. Those opposed, please raise your hands. Mr. Rice, Mr. Berliner, Mr. Reamer, Ms. Navarro, Ms. Florine, Mr. Leventhal.
Yeah, I have some other.
All right, you still have the.
Thank you. Since we're discussing what we should be considering for in the next couple of weeks, I would like to ask that the porches and other decks be included in the part where you measure for the setback. I think it's on on page 3 of the memo. We talked that porches are not part of the the home that we measure from. I think we should. I think in many cases a porch or a deck is really the part of the outside that a person who's living there actually uses, and I think that it's only fair that they be included in the area for a setback. I also. Well, it would be something that would be a change to what we, I was asked, right. Yeah, I was going to offer that as an amendment, right. Yeah. And then also I was going to offer as an amendment, though I know that there's going to need to be some discussion about what we can require prior to someone filing, the vendor, the industry, filing for their permits. Whether or not we can require that they actually have a meeting with the neighborhood, whether we could require that they actually have to show why that particular pole or whatever they're doing, why it's required in the area that it's required in. Thank you.
Thank you, Mr. Katz. So you'll prepare those with council staff, and you'll circulate them, as will anyone who is going to be offering amendments. Mr. Leventhal.
One of the things I just wanted to address very quickly that I have taken seriously, I'm listening to all the input we're getting, and colleagues have alluded to it and constituents have alluded to it. And that's the question of, why do we need 5G? My phone works fine. I've got 3G, no problem, and my calls pick up, and I have a router at home, and I just upgraded my fast service, so I don't need this, and therefore you shouldn't allow it. And I have some sympathy for that, but I think it is not sustainable. So, some people might think that gravel roads are just fine, we don't need paved roads, but as a society, we move towards paved roads for a variety of reasons, public safety, among others. I recollect years ago, decades ago, when I was explaining to my dad what the World Wide Web was. And he said, I don't need that, I can just get information at the public library. But his belief that the services were adequate to him in the 1990s didn't stop the development of the World Wide Web. So people may be entirely satisfied with their cell phone as it works today, or with their landline, or their router, or their broadband to their home, or whatever. This product is going to come on the market. It's irrelevant whether we want it to or not. It is going to come on the market. It's coming on the market. And it will be in Montgomery County. And it will be in that town in California that tried to ban it. So, anything we do is at the edges and will have limited impact on what really is vast consumer demand for a product that is going to be available, whether we think it should be or not. I've found certain quality of life benefits from having lost the primary election, and one of those is that I spend a great deal less time on Facebook. I'm really delighted with that. I don't need to be on Facebook. And for those of you who may not be running again, I encourage you to read a book, try something other than Facebook. But I can't stop Facebook. I can't stop consumer demand for Facebook. It's a product that's widely in demand, and 5G is too. So that conversation just isn't relevant. I'm hearing it. I know people are sincere when they say, I'm fine with the speed that I've got now, but that won't matter. It doesn't matter. The 5G is coming, and we can provide a reasonable process to facilitate it, or we can be preempted by the FCC. Those are really the choices that are before us, and it took me a little while to understand that. But that's really where we are. We're not going to prevent 5G, no matter how much shaking of fists and, feeling of adequacy for our current internet service we may express. 5G is coming. This 9-member council is not powerful enough to stop it.
Duly noted. Mr. Rice.
So I just wanted to say that I think we find ourselves in a really good position now to where we can roll up our sleeves over these next couple of weeks and highlight a lot of the issues. I've taken a lot of notes, as I know many people have, and look forward to seeing what these amendments would actually look like. I do encourage our departments to make sure that they're working hand in hand with us as well to ensure that what we're thinking about in terms of some of these amendments are doable, and if not doable, and there are other things that we need to do, that we can set those in motion as well, so that it's seamless, sort of like what we were talking about with the enforcement piece. And so, Diane, I look forward to working with you and your department and really coming up with something that makes sense and moves us forward in terms of getting this done. I want to ensure that from my, and I can only speak for myself as an individual council member, but I know my colleagues feel the same way. We are really trying to come up with something that brings about and represents all of the issues that folks care about. This is not, and I don't want anybody to think that, and I know, Councilmember Leventhal said it earlier in his opening remarks, it'll get characterized that we're, rolling over people, we're capitulating to the industry, all those kinds of things, but I know where our commitment is to working with our community and trying to make something that's strong. I've already talked to Councilmember Hucker about some of the things that he's looking to do via limited use, and there may be something else that we can do regarding some of those neighborhoods and areas that doesn't necessarily involve a conditional use, but could provide some additional protections, additional input from community members. There are things that we can do, folks, that don't always require it to be. So again, this will be a process. We have 2 weeks, which is a long time in our book, to be able to get some of this stuff done. And so I just really look forward to working with my colleagues and really coming up with some strong amendments that I think are going to provide additional protections for our residents, but also provide them with what's going to be great service and a great amenity to our community as well.
So thank you, Mr. President.
Thank you. Ms. Navarro.
Thank you. So, you know, a lot of work has been put into getting us to this particular point. And I did consider, you know, what would it look like if we were to delay and to wait for the new council. And I think that truly considering the amount of work that has been put into this, considering the complicated nature of what we're dealing with here, which is really kind of like astonishing. I mean, we are talking about, you know, how do we stay ahead of technology as it continues on a daily basis to outpace us. And so it's not a place where I'm particularly comfortable, and I, you know, don't appreciate the fact that we're dealing with trying to kind of stay ahead of what the FCC might do, while having to acknowledge that it is coming. And so I'm not convinced that we can say or think that we could just put a complete stop. And as policymakers, I think it is our duty to figure out how can we best, within our ability, mitigate impacts to our residents. And so it is kind of a new frontier in many ways. And I you know, listening very closely to this conversation, I think we have arrived at some places where there are some, hopefully, some further actions and options that we can consider and that we can include in our amendments when we take this up again. And hopefully, you know, again, kind of lead this as we move forward. I don't think that this will be the last type of, you know, sort of groundbreaking decisions that legislative bodies will have to face. And so, so it is a bit of an uncharted territory. And I do look forward to working with my colleagues, though both current and future, on, you know, future pieces of legislation to strengthen some of these processes, you know, and on the enforcement, the Tower Committee, and how we can make sure that our residents have a better, you know, stronger voice. I think there are some other things that we can do, because at the end of the day, I think we have to set ourselves up to what might be coming our way nonetheless. So, you know, I appreciate everybody's input in this. I know it's been a lot of dedicated time and effort, but I think we have arrived at least in a decent place to move forward with strengthening some things, and then we shall see what else to do. It's kind of being between a rock and a hard place. You know, we could have done nothing and then just have to face whatever came our way, or really truly try to, in our own way, hopefully preempt what's coming. So just appreciate my colleagues' indulgence.
Excellent.
If I may,
Yes.
against Jeff's objection.
You want to chime in with your praise of the recent comments?
Yes, I do want to thank the council. I do want to say that we are willing to work with you, appreciate and recognize what you're talking about finding a way to manage the public input into the process. I will tell you that we have actually have draft information about the TFCG, because we have been looking at that and we've been kind of waiting to address that sequentially. But one piece I just do want you to please keep in mind, the FCC timelines, the shot clock. The current process right now on that conditional use would be 150 days, and they have reduced that down to 90 days. The conditional use has a public notice that goes out to the public, so you have to kind of shorten that period of time. For the other co-locations, it's 60 days to do action. So I would just ask, and we're willing to work with you, having tried to schedule meetings and finding a date that works for many people and doing it on short notice can be a difficult thing. So that's why when we looked at processes where things were written, having things in there where there are automated processes where people can sign up in advance, and any time that something's submitted to you, you automatically get them. Having other processes so that in thinking about as well how these work together, because where we are adding more analysis that happens at the Tower Committee as to which one's here and which one is there, that all sort of takes time and that builds in. So we're committed to working with you, but I just want you to be, for all of us to be aware of that those those shot clocks that we have in there that to try to find processes that work with that. And the last thing I'll just say is about the TFCG, because people
That's the
have-
Tower Committee.
The Tower Committee, so the Transmission Facilities Coordinating Group. The last thing I'll say about that, we created that in the 1990s. It was primarily initially designed that we had lots of different landowning and land management agencies, and so we wanted to have a place to coordinate. It was also intended to be something that could provide expert advice to them. That process, we have reviewed over 3,000 applications throughout the county. We have over 500 locations and 1,200 antennas in there. So there are things that we have looked at that, particularly as we have some of the small cells. Part of it was before that when we only had these larger towers and they were much further back and they weren't in neighborhoods, some of this process, and particularly placing them in there, and like any process where you have change, you have to try to make those amendments. So we have put some thought and some time and effort in that. We're happy to work with you on that. But I just kind of did want to explain, and there were also, I will say.
Okay, wait, no more alsos. Thank you.
Okay.
That was helpful, thank you. Mr. Elrich.
So I might look at some amendments on design issues, because I think that's one area that I'm not completely comfortable with, and so I'll see if there's something useful there. And you do not have any suggestions on the Tower Committee ready to go now.
If you give me a couple of days, yes.
Good.
I mean, we have a week and a half, yes. So within that time period, yes, I think that we will have something to share.
That would be helpful. The sooner the better, so that we can get some of the people who were very unhappy with that process to get some feedback and see if you're able to address it in that time frame. I just want to say, whatever we did today was not going to keep 5G out of the county. That's just like such hyperbole that it's ridiculous, since the last bill we passed brings 5G into the county. So this idea that somehow we were going to hold back progress or people weren't going to get 5G is just not true. Those of us on this dais that who have iPhones, I will tell you that the latest news is that iPhone is not embracing 5G, and may not for a while, because they're happy with 4G gigabit service, which gets you the same speed as what 5G gets for the purposes of a phone anyway. Not for broadcasting into your house to compete with cable, but for your phone, it's a lot of stuff. So those of us in this other technology will probably just have to look at other people with 5G phones and say, oh, well. But I think we'll all survive somehow.
Or shareholders will have a voice.
Showing your tech bona fides, Mr. Elrich.
So I'll be happy with my 4G phone for the moment, and we'll figure this out.
Thank you, Mr. Elrich. Mr. Bluner.
Well, Mitzi, thank you for your comments, because as you heard, I had asked Jeff for his analysis of the Tower Committee process, in part because for the very reasons you cited, it was really designed for a different era. And now the question is, given the concerns moving into residential neighborhoods in a way in which that did not do, prompts different responses. And so I do think we need to modernize it. And just as we did with the farm alcohol bill of saying, okay, we're going to pass that, but then we're going to have a review every 2 years, we ought to, if we pass the ZTA, which appears to be the case at some point in 2 weeks, we ought to simultaneously ensure that that process, in fact, is a process that we're all comfortable with and that residents are comfortable with, that they have some means by which to monitor and have input and see the process. So I do think updating this statute would be very helpful. I also wanted to respond briefly because a tabling motion is non-debatable, and I felt like I wanted to explain the reasons why I ultimately concluded that we should not table this action and that we should move on it, since it was non-debatable. And that is, I looked very carefully, and I have great respect for Mr. Katz and his view that we could use more time, and I think it is absolutely the case that we're ahead of our public and that our public is nervous about it. And so I have sympathy for that. But I also heard our counsel say that there's risks associated with that, risks that could result in the applicants being granted their applications across the board without the standards that we're seeking to do. That's a serious risk, and therefore we would not be doing our residents a service by delaying. We would actually be making their lives worse. And secondly, I don't think we're going to learn a lot more in the next 3 months. And so if there isn't a whole lot more to learn, and my goodness, a lot of work has gone into this. For 2 years, a lot of work has gone into this. And so the notion that we're not able to make a decision now based on what we know now, in the absence of some notion that out there we'll learn more, it felt like, no, this wasn't the right thing. And then finally, I would say, as much as I would love Andrew Friedson to be sitting here and making this next call, I don't think it's fair to the new council to come in 2 months to be dealing with this kind of issue. And in some ways, it's easier for Mr. Leventhal and myself and others who are not going to be here to bring whatever wisdom that we have to bear with respect to this, and to act responsibly in the face of community upset. And the community is upset, and you need to know it, which is why we need to bend over backwards in every way we can to make sure that the community has an opportunity to be heard with respect to this, because this is going to be a bitter pill for a lot of people. They're going to be angry. Of course, they're angry a lot, but this is not been an easy road. And but on balance, I felt like we'd run risk. I felt like we weren't going to learn much, and I didn't feel like it was going to be fair to the new guys, which is why I ultimately concluded, as much as we're ahead of our public, that it would not serve our public to postpone deliberations with respect to it. So, thank you, Mr. President.
Thank you, Mr. Berliner. Good comments. Appreciate that. That was a very thorough discussion. I think we covered a lot of issues, and we have some work cut out for us over the next 2 weeks. We are scheduled to take this up 2 weeks from now, and